9, 8, 7, 6, 5, 4, 3, 2, 1.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Hello, everyone. I'm going to wait a little bit here to see if it's going to tell me that I don't know what we're uploading. It's telling me I'm 97% through the progress of uploading. So hopefully we're live. I guess we'll find out. Looks like we're live on YouTube, and there's at least people commenting. Lovely. It's giving me a hard time. Okay. I don't know if we're live on Facebook. Can you check that for me?
Check what?
Facebook.
Yeah.
And Rumble. So in theory, I did post that we're going live most likely just on YouTube today, but in theory, we are actually live on Facebook and Rumble as well. I wasn't sure if it was going to work out, so we're waiting to see if that is the case. And I'm back to trying the streaming service that I was using months ago before we switched to OBS, before we then tried to do Rumble Live. And we're going to see if it works. We had various technological issues with that initially, and we weren't able to make the calls work. So we're going to see. We're going to see if it works this time. Hopefully it does. But at any rate, I was just kind of waiting a minute to make sure.
Yes and yes.
Oh, good. So apparently it did work to go live on both Facebook and Rumble as well as YouTube today. So that's awesome. So welcome and hello to everyone joining us on all three platforms. Let's see. Okay. Just checking the comments real quick before I get us going on taking calls, but yes, and I can't see full names, but thank you to those of you who are saying hi on YouTube. Like it's only showing me the first few characters of a name, but oh, you know what? It's supposed to be showing me. Hold on a second. It is supposed to be showing me the chat. So why is it not working? This is awesome. I don't know if you guys can see this, but I'm seeing it says chat box. It's supposed to be showing the chat, but it's not showing the chat. So give me a second here just to see if we can get that. Oh, I can't do it any other way than when we're in a live stream. So give me 1 second. I'm going to try to get that pulled up. This is why none of the technology ever works the way that it's supposed to. It's super frustrating. There we go. So bear with me just a minute, guys, while I see if I can get our chat working properly. Really? I'm already logged in. If it doesn't work, then it doesn't work. Then we can't show the chat, but I feel like that helps the conversation sometimes for you guys to be able to see. And then if somebody's commenting from another platform, you guys are able to see that, and we can all just, be in the know and be able to participate with what's going on in the chat. So I'm going to give it one more try here. Chat box supposed to be working. It's enabled. I see 1 comment, 2 comments. Awesome. I was wondering about that. So Liberty Warrior tells me that my lip sync is off. And that sucks. Well, oh, yay, chat box. It's so helpful with how big it is and all. This is ridiculous. It's even tinier than the Rumble Live chat was. You guys probably can't see that at all. Wow, it does not, there's no way to make this any bigger? That's useless. Okay. Sorry, guys. I can't control any of that. That sucks. But why is okay. Anyway, I do see a lot of you just saying hello. I'm just trying to make sure there wasn't I did not hear about the arrests and expulsions on Vanderbilt University campus over peaceful protest and press coverage. That's interesting. And I'm just trying to make sure, other than the hellos and whatnot, somebody is, I can't see the full name. I just see it says generally. Somebody with the beginning of the name generally on YouTube says that they would like to interview me for their show called High Noon. So that sounds good. Says you're going to email me shortly. Jerry Lewis is joining us on Facebook. Nice to see somebody on Facebook jumping in. And looks like the Michigan AG is at it again. Lovely. Okay, so looks like, all right. Looks like I covered all the hellos, and the email is on our website. If you go to any part of our website, just I'm telling you where to find it, and never, in case you forget what I'm about to say, it's contact@restorefreedomkh.com. But if you're looking, there's I think there's a contact us page. Support, something like that. And anyway, it has links to all of our social media, but our email address, and the email, is that it in the bottom of the website? I know our PO box is. I think our email address is also in the footer of the website. So any page that you go to, you'd be able to see it. Mike's going to check on that for me. But anyway, as we get going, oh, okay. There we go. Now I can switch buttons here. Okay. So the phone number to call in is 616-303-0093. And hopefully the technology works, that I can see that you're calling, accept a call, and we can go from there. But we'll see. Is it on the bottom of the website?
It takes forever.
Oh,
No, it is not.
It's not. Oh, that's interesting. Okay. It's somewhere on the website. And it just occurred to me that something that I usually do when we do our earlier show, it's automatically sets my computer to have priority, and it makes the streaming easier and all that other fun stuff. Hello, how are you doing today?
How are you?
Good. Give me a second here. I'm trying to turn up the volume, press a few buttons, and hopefully I can hear you. Let's try this. What is your name?
My name's Rob.
Did you say Rob?
Rob, yes.
Okay. And are you calling from West Michigan today?
Yes.
Okay.
In your neck of the woods, in fact.
Yes. Give me just 1 second. I can't find my computer. Can you make it priority on the Wi-Fi? Make sure I don't have any issues. One of the benefits of doing the evening show, then Mike's at home and he could sit next to me and help me with some technological issues as they arise. Hopefully it'll fix any syncing issues. We have a caller calling in from the 443 area code, but let me get a chance to talk with our first caller from West Michigan first, and we'll go from there, and you can give me a call back when I put the call number back on the screen. But anyway, so Rob from West Michigan, what kind of legal or constitutional issue are you calling about today?
Well, I've got this case that I'm trying to bring against the city of Wyoming, Michigan for unlawful arrest, malicious abusive process with intentional infliction of emotional distress. The thing is, I've got all of my evidence. It's very well documented. There's no debating the facts of the case. Essentially, I was arrested for attempting to file a complaint against the Wyoming city attorney. And I was essentially charged with harassing communications, although the kicker is that I recorded all of my conversations. Okay. So there's no real debating what was said. Essentially, how do I put it? Well, like I said, I was arrested for attempting to file a complaint against the prosecutor. And she was also ended up being the one prosecuting the case, which was a huge conflict of interest for starters.
Yeah.
But as I said, I recorded everything. There was no debating what was actually said or the context. And there was absolutely nothing harassing about it. They said that I was threatening and harassing. And they presented evidence. I could go into it, but to cut to the point, everything's documented. There's really no debating it. And I was dragged through a year of this malicious prosecution. And of course, I got a public defender who didn't want to do their jobs. They didn't really want to look at the case. They didn't even want to turn over discovery. In fact, I had to fire them because they refused to turn over discovery. I actually had to lay it out like an ultimatum. Hey, I've asked for discovery 3 times already. You've ignored every request I've made. So for my 4th and final request for discovery, I'm going to say, give me discovery or step off the case. They actually opted to step off the case than to provide me with discovery.
So they were given discovery from the prosecutor and chose not to turn around and let you see it?
Yes, ma'am. And their excuse for that was because it was on an Axon system, which only gave access to them. I'm like, well, I'm the defendant, and the court rules say that I'm entitled to a copy of discovery. So if your system is failing, that's not my problem. That's yours.
There are some,
in any case,
there are some systems, just so you know, there are some statutes that do prohibit clients from getting discovery about themselves, which is totally asinine. It flies in the face of all due process. But in Michigan, I do know that in certain cases, there are actually statutes that prohibit defense attorneys from sharing some discovery with their own clients about their own case. Not to say that that's for sure what applies there or not, but anyway.
Right. With regards to this case, that's irrelevant. The judge agreed, when we had the motions hearing for the legal counsel to withdraw, the judge agreed with me, that, they should have provided it. And ultimately, I got a new attorney and I was provided it. But at the end of the day, after an entire year of being dragged into the courts, sometimes for no reason at all because it got canceled without my knowledge, it finally came down to the final pretrial conference about a week before jury selection. And it was me and my new attorney, and basically we sat down, and I kind of defied, because I've done some study and I'm pretty well versed in the law, so I'm a little, and so we kind of defied the norm for these types of things, where we sat, normally you go in and they make the client wait out in the lobby like the kid while the grown-ups go in and have their conversation. I'm like, no, we're not going to do that today. I'm going to actually sit down. I have some questions for the prosecutor. We're going to get to the bottom of this. And so when we did that, and I told my attorney, I'll let you speak. I'll just chime in when I feel it's appropriate. But when we did that, we finally ultimately got to the crux of the matter, where the problem is with harassing communications. It's a key element is intent. So in order for her to prove her case, she has to prove that I intended to harass them, when in fact I was just trying to file a complaint and ultimately petition for a redress of grievances. And that is clear in every conversation I had. It's all clear and relevant and verbally stated in my recordings. And so it was a matter of intent. She had to prove intent. And she actually admitted during that final pretrial conference that she didn't believe that I had the intent to harass. And so therefore, she admitted she didn't have a case, but she still wanted to persist in offering a plea bargain, which was completely unacceptable. And really what it really came down to, after she admitted that she didn't believe that the intent was there, she claimed the real reason, and she stated, and I recorded it, she stated the real reason I was arrested was it was a consequence for posting things on the internet. So,
Okay.
First of all, I was flabbergasted that she admitted, one, that there was an intent. I don't think she had meant to do that. It kind of slipped out. But there's that already out on the table. And then she comes out with this other statement saying that the real reason I was arrested was because I posted things on the internet. Right. Not that I posted illegal things on the internet, not that I posted anything wrong, but really what it came down to was I posted their corruption on the internet.
Right.
And so basically the thing is, I've got this all documented. The case is dismissed. She knew her case was cooked after that, and she had to drop it. And I wasn't going to take her plea bargain. But even still, her ego would not let go without trying to impose stipulations on me. And I said, screw your stipulations. I'll give you some stipulations. One of my stipulations was that you need to quit violating my First Amendment right and unblock me from posting on your Facebook page, which she agreed to and then never followed through. So now that agreement is null and void because it's in breach.
Yeah.
After explaining all of this to you, and there's more, and I could go into a lot more details, and their actions are atrocious and egregious. I was threatened by the deputy chief. I have that on record. I have tried to bring this case to attorneys here in West Michigan, and I'm getting to my question. I know it's not limited to just West Michigan, but it seems damn near impossible to find an attorney that's willing to take this case. I've had a number of attorneys look at the case with particular interest and tell me, yes, it's a good case, but I can't take it for such and such reasons. One of them, well, I only practice on the east side of the state, you're on the west side. You know, little reasons like that don't really quite make sense. It seems like it's a fairly straightforward case. There's no debating the facts because the facts are all documented. She even admitted that I was arrested for posting things on the internet that they didn't like.
Right.
And I'm having such a difficult time finding an attorney. What advice can you give me? What can I do to find an attorney? What can I do to get an attorney to take this case?
Well, first, I don't know that you would really succeed in filing in a state court. I mean, maybe, but you probably want to look more at filing a federal action relating to the malicious prosecution and abusive process and, you know, all kinds of First Amendment retaliation, things like that. So, you know, then you have to figure out what kind of court, but because that then tells you what attorneys would even be available. So, for example, if it is a state court claim, legally speaking, any attorney across the state of Michigan who's licensed, you know, in the state of Michigan, or even somebody like myself, you know, I don't live there anymore, but I'm still licensed, you know, could take a case like that. But if you are going to try to focus on a federal claim, then based on it being in Wyoming, Michigan, which is in the greater Grand Rapids area, West Michigan, you would need to find somebody who's licensed or admitted to practice in the federal district court in the Western District of Michigan. So Michigan has, for federal or trial level courts for federal level, there's two. There's the Eastern District and Western District. And the Western District, it would be, for you in Wyoming, it would be the Grand Rapids Court. It's actually the same courthouse where we were for when the day that Ryan Kelly was arrested in 2021 or 2022, whatever year it is, I forget which one, but when we went to the courthouse that day for that, it's the same courthouse. right in downtown Grand Rapids. But so you need to look at attorneys that would be licensed to practice there. Now, if somebody is, say, in Detroit or Livonia or Lansing or anything, on the east side of the state, and they're telling you, well, that's not where I practice. First of all, that might be because they're not admitted to practice in the court that you most likely want to look at. So that's a very legitimate concern. Number two, although a lot of things are e-filing and, just different things like that, typically the trial itself, if you get to that point, is going to be in person, and it's going to be in Grand Rapids. So if you have an attorney that's in, Saginaw or, Marquette or Detroit, they might not have the resources to do that because they can't just go, for the day or, for trial that day or for a hearing in person that day. It's going to be overnight stays that they would have to have. And then oftentimes things might get shuffled around or moved a little bit. So then what if it ends up getting moved to the next day or something of that nature, especially if you get into the realm of jury selection or something like that. So those are things that you really do have to look at. There's a lot of reasons why attorneys are crappy and they're terrible. They're often awful people. They don't know the law. They don't represent clients' interests oftentimes. So I'm not defending attorneys, just for the sake of defending them, because for the most part, they're awful and they give people like me a bad name. However, these are legitimate things that you need to realize do exist when you go to look for somebody. Plus, it helps if you have somebody who knows the district really well. So, I have, for example, some experience in Western District of Michigan Federal District Court. But when I told Ryan, told Ryan's wife initially the day he was arrested, and we didn't know where he was taken or what was going on or what attorney they might otherwise get. I said, listen, I'm admitted to practice here, but I was here just for a funeral and I'm on my way back to Florida today. And this isn't my greatest area of expertise. So I don't feel like I could do his case justice because I knew, being a J6 case, it was going to be an uphill battle. And same thing, a malicious prosecution claim where you're trying to get someone in the government, granted it could end up being a jury trial, but still you're going to have a judge overseeing a trial. So someone in the government, the judge, to allow through a case where you're saying that the prosecutor acted improperly and therefore there was an arrest also that was improper. So there's going to be, Wyoming police, department issues and things like that. There's a lot of implications there. So it's also going to be an uphill battle. Now, if you find an attorney willing to take that case, first of all, you need to share their contact information with me because I have my case that I want to bring against the Allegan County Sheriff's deputies and judges and prosecutors that were involved in my unlawful violent arrest from 2020. And I have not been able to find somebody with the right credentials and experience and constitutional willingness, quite frankly. So how do you find someone like that? Honestly, I really don't know. I would say you could start with looking in the, doing a Google search. And I don't know if there's actually a listing. If you can contact the Grand Rapids office, the Western District of Michigan Federal District Court, if you can find a listing of all the attorneys that are admitted to practice specifically there, or if you want to just start with the State Bar of Michigan and just see if you can narrow things down. Maybe people list themselves through the State Bar as being civil rights attorneys or something of that nature, and just print whatever list you start with. And it might be 100 attorneys, and just start calling each one and figuring out who's licensed in the right court, and then their willingness. So
and I've done all that, everything you're telling me. It's like I'm already aware of what you're telling me, and I've done all that. What I'm wondering is, what can I do to make my case more attractive to an attorney? Because, like I said, I've actually, I posted everything on the internet, and I actually presented it very much like I would an actual trial. And I'm just doing that to try and make it more attractive to an attorney, so they can actually, instead of listening to me, blabber on for 20 minutes about the case, they can actually watch me in a very articulate fashion.
Is it in a video?
The fine details. Yes, and I do that, and I put all this work in, and I can't even get attorneys to watch it. In fact, most of the time, I can't even speak to an attorney. I speak to their legal aid or their interns, and they don't know the half of what they're talking about. And so I feel like a lot gets lost in translation through them, between me and the attorney. So I'm just looking for any tips that you can tell me to help present my case in a more attractive, in a manner that's more attractive to attorneys as well.
So was the case, did it end up being dismissed? Is that?
Yes.
Okay, so that's where you need to start, because even with me, I didn't know where you were going or whether the case was actually dismissed or not. So I would start with, I have a wrongful arrest, and I want to file a lawsuit, a civil lawsuit for malicious prosecution against the prosecutor involved. And it was the underlying charges were dismissed. And the attorney even admitted on record to that there was no basis for the actual charge, but rather that it was retaliation for me posting things I didn't like on the internet. I mean, literally as simple as I just said it right there. I would say that in your, beginning email or what have you. And then you said you have stuff online. I would make sure it's not something like a Facebook or whatever. Make sure it's like, just a neutral website. And I would upload the documents right to that website and have links, so that in this email, the body of the email is what I just said to you. But then you let them know, okay, so the dismissal is right here, and you've uploaded that paperwork and whatever evidence that you have that they admitted that it was retaliation, there was nothing, actually threatening about your communications or whatever, that is in another link that you have uploaded. Things like, you know what I mean? So each of those key points that I said, you have the evidence there, but it's
essentially that. I'm sorry, go ahead.
Yeah. So I would just keep it as short as those few sentences that I just said, and just say there's obviously a lot more here. I can expand on this. But I know that there's a statute of limitations on certain claims. And so I'm going to just start with this and ask that you please let me know either way if you're interested any further. And then if you go with the listings through the bar, then, you oftentimes are getting the attorney themselves. Sometimes they have, like an info at or whatever that's going to a secretary or something like that. But oftentimes attorneys from the bar listing list their direct email address. And so especially if it's something where you're sending them an email, they might be checking it at hours that it's really awkward for them to try to call people back. It might be 9 o'clock at night, but they're finally getting through some emails or whatever. And so you want to be very clear about what you're asking for in the title of your, the subject of your email, and that very short and sweet to the point with those keywords I mentioned. I mean, go back and watch this part of the video and just copy down those exact sentences in that order. And then make sure you have all the evidence you're talking about is easily identifiable, and they can look it up, and they're able to read the documents themselves, more than hear you talk about them. Or if it's video or whatever, they could see that, directly themselves. And so I think that would be something that it would show an attorney that there might really be something there, and they might be more willing to have themselves look at it. If it's quick in and out, they can read it, they could see, they could, dig in there as quickly or as long as they want to, and decide if they want to take the case. So those would be my best recommendations to you. That's kind of what I've done with attorneys. I've called a few that I know. But basically, even the ones that I know didn't really know all of the details of what was going on in my case. So I gave them a link to the certain documents from my case. I laid out what some of the main issues were and who the main players are that I think should be, have the suit brought against them. And so it was, it's a way to just kind of like, here's the email, here's tell them what it's about as quickly as possible with the keywords, but here's all the information to back it up should you decide to look at it. So hopefully that helps you. I mean, I'd love to hear an update. I used to actually work, when COVID started, I was working in a school in Wyoming doing restorative justice. So I definitely know the area. And of course, my favorite thrift store in the world, Goodwill Outlet, is there. So
that essentially, what you're saying is essentially been my game plan so far. And I guess I find it really concerning that even you are having difficulty finding an attorney. It's very disheartening. It almost makes me feel like I should just give up because, I mean, everything you're telling me I already know and I've already been practicing and demonstrating. And I'm just getting nowhere, spinning my wheels. It seems like there's just no justice and there's almost no point in even seeking it.
Well, yeah. Yeah, sorry, I was reading a comment. Someone was telling you to contact Tom Lambert. I've known him since before he went to law school. Must be a brand new attorney because he must have started. When did he start going to law school? In 2020?
No, it's probably before that.
Really?
I don't know.
Okay. At any rate, he's a fairly relatively new attorney, but he's not like a young guy. I mean, he's remotely my age. So obviously he's quite youthful, I should say. But anyway, I thought his focus was mostly going to be on Second Amendment issues. I could be wrong. I mean, last time I spoke with him about that type of stuff was while he was in law school. So he might be someone to check. He is smart. You know, he used to be the president of Michigan Open Carry. So if somebody's saying that he opened his office right in Grand Rapids, so Tom Lambert, anyway, is a name that people are giving you.
Cool.
So check him out.
I will look into that.
If you do call him, tell him I said hi. So sometimes if you have another attorney's name in there, then they're like, oh, okay, and it gives a little bit more context. Sure. So yeah, if it doesn't work out with him, don't give up. I mean, I'm feeling very disheartened about my own case because I just don't have it in me to do it on my own. But yep. It's just,
well, that's actually how I found you. And of course there is that old thing. I mean, I'm almost half tempted to go pro se myself because, like I said, I've studied law for a good 10 years now. I've got a good understanding, but there's that old saying, he who represents himself in court has a fool for a client. And the Wyoming city attorney proved that to be true when she represented her own interests in my case.
Yeah, so, but I don't think that's necessarily true. I think it's if you can separate yourself from the emotional side of your case to really focus on what the legal issues are and really be able to, you know, see things from a judge's perspective, from the jury's perspective, you know, what's the prosecutor going to say, you know, what's the other side going to say when you sue her? You need to be able to anticipate legal arguments and fight against them and things like that. I mean, if you feel like you're comfortable doing it, I wouldn't dissuade you from doing that. Just, you know, really do some research about if you want to file a state level claim or federal claim, or which one would be your main claim. And then it's, you know, if you sue, and I had a case in federal court in the Western District of Michigan. I actually filed it in Ionia County Circuit Court, and I was suing the city attorney, or the city manager of the city of Balding at the time. She's long gone now, but her overpriced attorney paid for with my tax dollars, moved it to federal court, I think, thinking he was going to scare me. I don't know. But I was like, sweet, you moved it to federal court. Now I don't have to pay every time somebody files a motion. And I ended up filing several motions. So it saved me the filing fee each time. But then I had to pay for parking in downtown Grand Rapids. So at any rate, it's, you know, it's not that you shouldn't do it to, you know, that representing yourself is bad. And for myself, I probably would be the best attorney for the case, but I have other cases. I have another appeal I'm working on right now for other issues down here in Florida. I have a freedom fighter who's a friend of mine who might be on the chat right now, who's going through his case. And so we have a trial coming up for him. There's actually 2 freedom fighters that are involved, but I'm standby counsel for one of them. So it's, you know, it's just, I don't know. I just feel mentally burnt out from, because my case lasted 2 years. I mean, the judge moved, I had 8 different trial dates set that I never got a say about. I mean, I even drove all the way up from Florida for a couple of them before he said, oh, just kidding, never mind, we're going to move it. Oh, thanks. So anyway, I don't want to discourage you from doing it yourself, but why don't you set yourself a time frame, between here and the end of April, for example. I mean, you have to look at what the statute of limitations would be. But if it's a fairly recent case and you have, a period of time yet, give yourself a set period of time to try to find an attorney, and then say, you know what, if I don't find an attorney that I'm comfortable with, that I really think that would do a good job, who's willing to take the case by X date, then I'm going to strongly consider doing this on my own, and then see what it takes to jump in and do that.
That was my thoughts exactly. So.
Yeah.
Okay. Well, I appreciate you hearing me out and appreciate your time.
Yeah, you're welcome. And I'd love to have a call back to find out, what happens down the road. So let us know.
Absolutely. Sure. We'll do.
Have a great day.
Okay. Thank you.
Yep.
You too. Bye.
Bye. Okay, guys. So I forget. It was a 443 number. If you're still there and you have a question, you want to give me a call back, you can do that. After that, we had 2 different calls coming in from a 270 area code. I don't know where either one of those are, 443 and 270. I have no clue. So at any rate, if either one of you wanted to call back, go ahead and do that now. You can call in at 616-303-0093. In the meantime, I will let you guys know, because I've started this update several times. I will let you guys know that I don't know why this does this to me. It's so frustrating. Anyway, but I have to file the next round of appeals in our Ormond Beach ordinance violation case. So we're having to file the next round in the 5th District Court of Appeals. It's more filing fees. There's going to be all kinds of things going on there. Any help that you guys might be willing to help me fight this fight, and you're going to be, aside from the fact that everything I do is to fight for freedom anyway, there's some big things that I think, some big issues that I think you guys would really be interested in funding, supporting, whether it's $5, $10, $500, $5,000, whatever it is. And you could go to, in fact, I was going to share the link. I think I almost had this. Yep. It's givesendgo.com/SaveHenryHome. But, oh, that was not, it's not going to let me do it, is it? Okay, I think it's sending now. It's not showing me correctly on here, but anyway, get back to the right screen. So if we get a phone call that comes in, anyway, I believe that's the right link. If one of you wants to check it out and make sure, that'd be great. Let me know, because I had to type the rest of it in from memory. It didn't grab the whole thing on the screen I had it. But anyway, it's our Give Send Go link. I might not have updated it yet to talk about the fact that we now have the first round of appeal decisions in, and the judge ended up saying in a very roundabout way that they can't come on our property to physically tear up our fence, our privacy fence from our backyard, our 2 shipping containers in the backyard, or our pavers. But she did say that they can fine us into infinity and use those fines to create fees. She literally said they can fine us every single day from here till all eternity. But then once they get to a certain point, then they can just go ahead and create a lien against not only our home, but our real property, which is our home, but our personal property. And they could try to enforce it against our personal property and literally take everything we own. That's insane to me. If you don't think that's an appropriate thing, if you think that any governmental entity being able to fine someone for all eternity for something that does not harm any other human beings, then help me fight this fight. Like I said, $5, $10, $50, $500, whatever you got, if you're willing to help with that, please do so, because that's one of the main issues here. The other issue is the fact that it's not required in the first place, and they're not actually reading all of the codes. In fact, when it comes to the codes, I don't think she really even read that part of my brief or my reply brief at all. Or the fact that there's parts of the code that the way they're written, it's making it literally impossible to try to meet. So if the law is the law is the law. And here's the thing, she did a lot of things. I didn't bring it in here with me. I had some phrases underlined. She kept saying things like, it's like her whole point was to insult me. She was saying things like my arguments were inartful and they weren't cogent and they weren't, all these other things, right? And she's like, oh, it's terrible and whatever. So she never insulted once the prosecutor or their representation, the city attorney's representation, when my reply brief in large part talked about how they plagiarized a whole bunch of cases, cited a whole bunch of cases that are from other jurisdictions that are not binding, how they cited unpublished opinions, how they cited things and misquoted them. Give me just a second, guys. Hello, caller. Where are you calling from?
I am calling from Miami, Florida.
Miami. Okay. And what is your name?
My name is Miguel.
Okay. Give me just 1 second. I'm just going to finish my thought off and get right into your call. So at any rate, she literally didn't care one iota about the fact that they did all these things and all their arguments are trash. Didn't insult them in any way, shape, or form, but made it a point on every single page to basically talk about what an idiot I was. And I thought, you've got to be kidding me. That's your main focus. So what should matter is, was the law followed? Did they follow the law? They did not. The magistrate did not. They did not follow the law. And is the law, as it's created, does it make it so that it's virtually impossible for me to comply with portions of it? And are they applying it unequally in violation of the Equal Protection Clause? Those are the main questions. And I don't care if she wants to say it's not a substantive due process argument or it's a procedural due process, or I don't really care at this point. I think I'm just going to say, guess what? The law is the law is the law. Is it not? They should have to follow it. If they didn't follow it, how do they win the case? So that's something that if you guys want to support or even just know more about, I do have some information on that Give, Send, Go. You can, there's links to be able to see the short video I had done about it. I'll probably have to update that, as well as the original documents. And on my website, I think it's restorefreedomkh.com/OBcase for being able to see the documents that are on there. I don't think I put the judge's most recent order on the case, which would be important for you guys to read. But I will be doing that. Okay, so Miguel, are you someone that had tried to call a few times ago and we just weren't able to make it work?
Yes, that's correct. And I was calling the wrong number, so I apologize.
Oh no, I think the one night you were calling the right number. I just couldn't get the technology to work. So you were,
yes.
And I think it was the Rumble Live. Were you the one trying that and it wasn't working? Okay.
That's correct.
All right. So what are you calling about today?
Very good. And thank you so much for taking my call. I have to jump on another call at 8, so I'm going to ask my question and then I'll listen on YouTube. But thank you for doing this. And so I have a federal litigator. I was very fortunate to find one. He's very good. He's won 5 out of his 6 cases. But for this particular question, I had an administrative hearing, so code enforcement. we have the hearing officer who is not licensed to practice law, and Miami-Dade County gets around that because the county attorney's office is the general counsel to the hearing officer. So what the question I have is, can the county attorney litigate against me for code enforcement, as well as give counsel to the hearing officer who's supposed to be neutral, or would that be a violation of the 5th and 14th Amendment? You know, is that an unfair hearing? Is there due process in that? And I'll go ahead and hang up.
Well, repeat that question one more time, because I want to make sure I understand the two sides that you're saying. Can they do this and then this?
Correct. So the general counsel to the hearing officer who is not a licensed attorney, it's just any regular person out there who wants this position. Can the general counsel be, for the hearing officer, also litigate for code enforcement against me or any defendant, or is that a bias now hearing instead of an impartial hearing? Is that a violation of due process?
Now, when you say the hearing officer, you mean the person that's presiding over it as though they're the special magistrate?
Correct.
Oh, then forget any kind of worry about ethics. You can go straight to the state law about that. Now, granted, I will give you the disclaimer that this is not advice because I'm not a Florida licensed attorney, but I have read Chapter 162 of the Florida statutes. And right in Chapter 162, I don't know if it's somewhere right around like 162.09, 0.08, somewhere in there where it's talking about the procedures. It says that an attorney, like city attorney or whatever, can either represent the, code enforcement in the hearing, or they can essentially be providing general counsel to the local code enforcement board or special magistrate, whoever is essentially acting as the judge, but they can't essentially represent the prosecution as well as represent the judge. They could do one or the other. There's a state law that specifically says that. So that would be a very easy point for you to make. I just don't remember the exact statute, but Chapter 162 would be what you'd want to look at.
That's correct. I've read that, and that's 100% correct in state. Would it be a constitutional violation?
That's a good question if it's a constitutional violation. Definitely, I would say it's a due process violation because they're not following literally the procedures and processes that are laid out in state law. And you can't have someone acting in an executive branch function and in a judicial branch function, and a prosecution, the prosecutor or code enforcement or whatever, in that capacity, they're acting as the enforcers of the law, so executive branch, whereas judicial branch, obviously, if they're in the capacity of special magistrate or general counsel to, the code enforcement board, that's judicial branch. You can't be serving, especially in the same case, you certainly can't be serving in both capacities at the same time. So
that's fantastic.
You might very well have a good constitutional argument. How you would best want to craft that, I guess I'm not quite sure off the top of my head, but I mean, no doubt, at least with the plain statute, I don't know how they could deny relief based on that.
Correct. We appealed today, and we'll see what happens. I do have a separate attorney on that one.
Okay.
I appreciate your time, Catherine. Thank you for what you're doing for the community.
Yes, thank you. Have a great day.
You too. Bye.
All right, guys. So, yes. Trying to think of where I was mentally before we got that call. And I apologize, guys. I'm not even sure it's even worth having the comments scrolling on the screen. Many of you might be watching from a phone. Certainly, you might not even be able to tell that there's words on the screen next to me, let alone what they say. It's so absurd that I can't resize that. I was so excited. I couldn't test it out because I can't test out what the comments look like until there's comments there, which means I have to wait till I'm live, unfortunately. But I had the box all ready to go, sitting there waiting. Looking to see if any process is not with due process of litigated law, policy, or procedure, it is without a doubt a 14th Amendment violation. I'm not sure if I 100% understand what Moon Creator on YouTube is saying there, but I believe that I agree with what they're saying. And I think if I understand what they're saying if, especially when you're talking about the government is bringing a case, whether it's code enforcement or, whether it's the prosecuting attorney, whatever it is, right? If they're bringing a case against a citizen, so it's government agent versus citizen. If the government agency or agent is not following the law, if they're violating the law, state law, federal law, or the Constitution, if they're not following the procedures or not following the law involved, that should be considered a 14th Amendment due process violation. That's essentially what my argument was in my appeal so far. Excuse me, when the judge said, all the insults and threw out there that it was so inartful and that it's not this and it's not that. And, a substantive due process claim can only be brought against legislative action, not executive action, and so on and so forth. And if it's against that, it's a low standard, it's a rational basis test, and so it's arbitrary and capricious is what it has to be in order for it to be determined bad and for you to get relief, all that kind of stuff. And to me, I'm thinking, I don't know how to write. I guess at this point, I just need to write it this way. I just need to write it not as an attorney, and I'm not a Florida attorney. But I need to write it as a human being that says, listen, the law says this, not a bunch of case precedent, not a bunch of gobbledygook, not a bunch of this is just the way we do things, but literally the legislature put into writing A, B, and C, and the city did not follow A or B or C. So therefore, their case gets thrown out. That's exactly what I plan to say. Apparently I just need to tell them up front, listen, apparently you guys have deemed me here as very inartful and inelegant in how I craft my briefs, which I work extremely hard on. And I can tell you, I put a lot more hours and thought and intelligence into my brief than the city did into their brief. And you could read both of them as well as my reply brief right on my website, restorefreedomkh.com/OB-case. You can see the documents for yourself, nothing to hide. But at any rate, hey, apparently I'm inartful at doing this. How about we just screw the niceties, look at what the law says. If they violated the law, they're the ones that brought the case against me. If they're the ones that are violating the law, they should not be able to obtain relief, let alone relief that will literally last for all eternity, for them to be able to add charges upon charges upon charges and take our home and take our property, our private property, our personal property. That is absurd. So at any rate, that's what my argument is going to be. And yes, I would think that would be what this other moon creator was commenting. I guess I'm going to write a note here. I don't know what they're writing this Stallworth v. Hearst, what that case is about or what jurisdiction, but I do see Jay Curvitt here commenting, and I just want to say thank you for the donation that just came, I think, yesterday, and just wanted to say thank you for that. I was trying to remember where. I think you were in Michigan. It's up on a shelf. I can't quite reach here the envelope, and it looks like you had a hearing today, and I apologize. You might have mentioned here in the chat just now or in prior conversations or something. I don't remember the details. There's several people all getting charged with bogus crap all at the same time. And it's quite honestly hard for me to keep it straight some days. Okay, so somebody was asking me, I think it's Disability Advocate. Again, I can't read the whole name on YouTube. Does Ormond Beach have a reasonable accommodation ordinance? I don't know if they have a reasonable accommodation ordinance. I'd be interested to find out. What's interesting to me, I will tell you this, in my hearing, when they tried to, when they were serving me informally and not according to the law with the case initially well over a year ago, I let them know that I'm hard of hearing and I don't know if I would need accommodations, but I had questions about what the setup was so I could see if I would need accommodations for my hearing disability. And they refused. I called the number on the piece of paper on the notice of hearing, and they refused to take my call. They instead directed me or transferred me to the city attorney herself. Well, she's like the assistant city attorney. The city attorney, because they couldn't be bothered to deal with me as an actual resident human being, disabled individual, American citizen, and responded to their action. I called the exact number I was directed to. They refused to talk to me about any disability accommodations. I had to talk to the city attorney about it. Asinine. Our courts are broken, Liberty Warrior says. That is very true. Miguel, looks like you're responding to disability advocate. Was that Hilton Napoleon? Was that the attorney you were talking to me about? I can't even spell. That's what happens when I try to write and talk at the same time. For those of you, the two of you that were calling from the 443 area code and the 270 area code, please go ahead and call in right now. You can call in 616-303-0093. Let's see. Let's see. I'm looking if there's any other questions or inartful in its presentation to the special magistrate. I assume that is someone, I don't know who B not yet is. Do I know who we are personally? At any rate, B not yet, you clearly have read the actual order of the appellate judge in my case. So that is one of the times that they were commenting, or that she commented that. But she didn't come out right and call me names. Let's be clear about that. It was more indirect, but she repeatedly was talking about how, like one of the comments here, inartful in its presentation to the special magistrate and here on appeal, I think is how she continues that sentence. Anyway, yeah. So at any rate, let's see. I do have, oh. Oh, okay, lots of you. Wow, so some of you, even on your computer screens, cannot read tiny print here on this chat. What is the point? Let me get over back to that screen, guys. Oh. Hello, and who am I speaking with this evening?
Hey, good afternoon, or good evening, Catherine. It's Bruce in Michigan.
Okay. You said Bruce?
Yes.
Okay.
I've been following.
Not what I would expect your voice to sound like if you were my father, but anyway, you're wrong, Bruce.
Hey, I've been following you for quite a few years here, and realize that we're all in this big spiritual battle.
Yes.
It seems to be. I have some similar circumstances that you've been in, different capacity, but the battle seems to be the same. I've got 3 questions. I'm going to try to keep them short and to the point and not overly detailed. But my first question is regarding an occupational license in a state that no longer has a right to work law enacted.
Okay.
And the question is, the occupational license is a public license. And in order to gain consent, they enacted or encouraged me to join a quasi-government agency and combine that with a private institution in order to exercise the license. And the quasi-institution acts similar to the state. For instance, LARA is the Licensing and Regulatory Authority. And in the problems that I realized after the fact, the state could only tell me, you know, we just issue the licenses. But it sounded like they're not necessarily regulating the licenses that they issue. And so ultimately what happened.
What occupation is this?
It's in real estate.
Real estate. Okay. So you're talking about the real estate licensing board. Is that what you're?
Not necessarily the board in particular, but the association that's related to that, which is out of state.
Oh.
And I held a builder's license for 28 years. And within that builder's license, I was never forced to join the National Association of Home Builders or any other, you know, association,
right,
professional association affiliated with that. And, you know, so I, under a certain confidence of doing and exercising that license with no issues, I proceeded to get the real estate license. And nowhere in the statutes for the occupational code says anything about you must join this third party in order to exercise your license. And I didn't find this out until I go to get employment with my first employing broker. And through non-disclosure and tacit agreement, you know, they bury that into our employment contract that you must join. And this wasn't disclosed to me ahead of time. And to make the long story short, the first employing broker who actually did reside on the state board previously, they failed to meet state statute obligations for the employment arrangement. And so that kind of daisy chained into, you know, getting a different employer, which they ended up failing meeting fiduciary duty. And then I daisy chained to find a different employing broker who they violated state statute and the rules that apply to that. So the challenge is all during this period, I'm going out to the public, gaining their trust to serve them, as I did similarly with a builder's license. And there was a bottleneck there because the employers didn't honor the state statutes. The association espouses that they're of a higher standard, and they didn't even meet the higher standard statutes, or they're not statutes but rules.
Yeah.
And so out of this whole thing, like I said, I have 28 years of experience, and I end up, you know, this results in, you know, less than minimum wage earnings for a number of years, where I've kind of extorted out to the public and, you know, gaining their trust, but then again, the bottleneck with the employment. So my question on that is, what potentially the 1983 matter or cause of action would that encompass or embody state actors, private companies, and the quasi association, which all together combined deprive me of my rights, or my privileges, I guess I should say.
So generally speaking, and I just want to clarify, you're talking about USC 42 USC section 1983 claim, which would be a federal United States Code federal claim. And
Correct.
It's been a little while since I looked up the language of the statute or looked at it from the perspective of whom it would be. Based on my best recollection, yes, I believe those three entities that you listed would essentially all be, could be part of that. They could be party to that lawsuit. As far as a cause of action, what specific cause of action? I mean, 42 USC it's generally, you have to say, like, what kind of thing is it that was done to violate your rights?
Right, you have to state a claim where relief can be granted.
Well, yes, in any case,
under Rule 12b-6.
Well, yeah, in any case, in any court, anywhere, you have to state a claim upon which relief can be granted, criminal, civil, whatever. Otherwise, your case can be dismissed. There's the same things in Michigan State Court as well, or any other court. But it has to be in terms of any of the, like, if you claim due process, for example, you have to be able to state what the underlying right or legal issue is that you were denied process for. So with the 42 USC section 1983, there has to be some specific right or privilege or something of that nature where it was denied improperly. And so there has to be something specific that could, easily be understood in the court system. So that would be the biggest thing I would think that you'd want to look at, is identifying specifically what kind of action under a 42 USC section 1983 case that you'd want to file. Does that make sense?
Yes, it does.
Okay.
And ironically and interesting, as I'm halfway through this and realizing the challenges, and I contact Laura, and they just, simply say, well, file a complaint, file a complaint, file a complaint. And that would just be through their administrative process, which there really isn't any remedy or relief for myself. That process really is affords the public a way to file a complaint against the licensee, and then the licensee is punished, essentially. But in their response too, was to file a complaint or hire an attorney. And of course, I contacted probably over 50 attorneys, and they weren't familiar with the laws. And one would say, well, you need an employment lawyer. One would say you would need civil rights lawyer. Then one would say, no, we can't help you. You need a business litigation attorney. And so get bounced around,
well,
throughout that whole process.
Yeah, quite frankly, your best bet is to have someone who is more so a civil rights lawyer, but a civil rights lawyer who has a good grasp and understanding of business law and, employment, the other areas that you mentioned. You need someone who has a good grasp of those, because if somebody is, they're more of a, well, if somebody's just the business lawyer, right? And they might know exactly what you're talking about in terms of, what the Department of Licensing and Regulatory Affairs is doing, or whatever, some of the other aspects that you're talking about that were the sticking points. They might know exactly what you're talking about there, but they wouldn't necessarily have the experience and know-how on how to translate that into a claim for relief in a federal claim against any particular party. Or you might have somebody who's generally good at civil rights cases, but maybe they're more focused on stuff that might be a little bit more black and white, a wrongful arrest, or some sort of malicious prosecution, or something, some sort of specific denial of rights, denial of public accommodations or something like that. And so they might feel like, yeah, I'm in over my head when it comes to the area that you're talking about. So I wouldn't give up, but I would, just keep looking for somebody who has, the basic know-how about the business side, but really is strong in the civil rights arena.
Right, and that's a challenge within itself, because you broke the mold.
Me.
But anyways, and part of this too, because I felt bad for the clients that were not afforded their opportunity, and I proceeded to contact the Attorney General's office under the consumer protection side, and also my inability to find a qualified bona fide employer that didn't require my joining or my association of this third party.
Yeah.
And when I asked for, please advise, what do I do? It's time for me to renew my license. Instead of them responding to me, I got a call from the Assistant Attorney General's office. And essentially they just said, well, we can't help you. We just defend the state in litigation. I'm like, well, why are you calling me then if you can't help me?
Yeah.
And my request was on behalf of senior citizens who ended up getting injured, through this action. And, essentially it just has gone nowhere as far as from the state, which I kind of find that strange, because they knew of the situation in the arrangement, but it's by tacit agreement. It's undisclosed and it's assumed. And so I'm just wondering if there's any other cause of action that would tie that back to the state, as far as, why aren't you disclosing this information? It's known and assumed. But like I said, in my previous license, I was never required to, affiliate with any third-party association.
Yeah, it's an interesting, and somewhat complicated question. There might very well be other causes of action out there, but without me having a full grasp of all the details, what I generally do, because I can't be an expert in everything, but
Sure.
what I generally do is I kind of jot some of the basics, the most, basic concepts of a particular case in mind, when I was working on the Allegan County case, my election day arrest case, or whether it's the Ormond Beach, municipal violations, supposed code violation cases, or any other case, that we're talking about, fighting the governor's executive orders, whatever. You have those facts and those main issues that you think are of main importance, and you kind of just have those bullet pointed, on a piece of paper in front of you. And then I would look at, a listing of what typical causes of action are. In fact, in Michigan, give me a second here. There is, where did it go? Well, I'm not finding exactly what I was looking for, but there is
the
one.
ICO books.
Yeah, so there's one in particular that I think would be really helpful. I can't seem to find that, but it's literally talking about civil causes of action, which is an ICO book. And non-attorneys can buy those. So if, go ahead and check that one out. But I believe it's just called Civil Causes of Action. The other one is called, I can't really read it from here. It starts torts, something, something. And
law and practice. Torts, Michigan law and practice.
Torts, Michigan law and practice. So I'm the nearsighted one. He's the far-sighted one. So it works great right now.
Teamwork.
Yeah. And then there's volume 1 and 2 of that one. So that's something that I literally just went through the table of contents, and I was like, okay, so what are some of the main causes of action? What are some of the things, and anything that sound like that might work? In your case, there's no arrest, so a malicious prosecution wouldn't be involved, right? But you'd still look at anything. Yeah, you'd look at anything that sounded like it might work, and then just read that section a little bit more, and the more it sounds like, yeah, that still might work, it might be applicable, then you just you jot that down as something to come back to, and then you just kind of look at it all there and take that full scope. And there might be federal causes of action, there might be state causes of action, and so those are things that you'd want to just keep doing a little bit more research. There's always, the unfortunate part is that there's so many laws out there, federally, state, locally. There's endless laws out there, that there's always something new to read about a law that's out there, or an option that's out there. So at any rate, I would definitely keep looking at that. And there should be any situation that's even remotely similar to that. I find that there's generally at least 3 different causes of action that get to what the problem is and that you could pursue. I just don't know what any of the things would be off the top of my head. But in general, those kinds of cases would be something where, yeah, there should probably be this type and this type and this type, and they're, of a similar nature, that all should be able to get you relief there. So, you might even want to seek declaratory relief, pursue a declaratory judgment, declaring that you don't have to, be a part of, participate in any kind of non-governmental entity. They can't force you to participate in an association just to be, to pursue your career or whatever. And then if they do, then you have that on the books, and at least it's something, that you could go from there. But anyway, I hope that makes sense. The Moon Creator on YouTube is saying 42 USC section 3631. That's vaguely familiar. I can't think of what it is.
I will look at that
off the top of my head, but I'm assuming they're doing that in relation to this call. So check it out anyway. But hopefully I've been able to at least answer some of what you were looking for. And I do wish you the best of luck in that situation. And occupational licenses, for the most part, I think should be voluntary. For the most part, there could be something that's out there that should be, it should be mandatory that there's a license for. But generally speaking, I think attorneys, for example, builders, barbers, anything like that, I think, it's a buyer beware situation. And I think if you have somebody out there that says, you know what, hey, I'm advertising my services as an attorney, and it's buyer beware. So you should say, okay, well, did you go to law school? Did you, how many years have you been practicing? What kind of, how many cases have you worked on, or whatever, right? How many courts have you been involved in? Something like that. It'd be part of the buyer beware. You ask questions, or, if you're advertising your services, you go ahead and say those kinds of things. Yes, I went to law school many, many years ago, and I had really decent grades for a single mom going through law school. And, I passed the bar, and then I passed the Michigan bar, and I'm part of all these other, I'm licensed at the United States Supreme Court. It should be something that it's like, it's something extra. It's like extra credit, or it's like saying, I have this special certificate that says that I really did a good job. it shouldn't be a requirement. If my husband wanted to be an attorney, which he never would be in a million years, but if he wanted to, shoot, at this point, he knows a lot more about the law than a lot of attorneys do. So he should be allowed to do that. But at any rate, different side note. But I do wish you the best of luck, and I appreciate you calling in, and also I appreciate the kind words and words of support that you've said throughout your call as well.
One other quick thing, if I can add, in regards to filing a complaint against an attorney, in this position or in this role as a fiduciary duty to a client, there was a series of events that happened that basically brought a breach of contract against the senior client, and there was a failure to review facts and law on both sides with the attorneys, and they basically, instead of even bringing it to court where the client could have, had some truth brought out, it went to mediation by kind of, not by threat, but by antagonizing or intimidating that, mediation is better because, the court process could be drawn out. Well, the truth didn't get brought out, and it should have been a motion to dismiss from the beginning, but instead the attorneys kind of played court sport with the senior clients, and it was things that I recognized up front and tried to dismiss or defray as much as possible, short of doing anything physical. I'm wondering if bringing that just in a small claims court against an attorney would air it out and expose the problem, or if there's just a better solution by filing grievance with the attorney commission.
It depends on what the scenario is, because in general, a lot of, especially in Michigan, but across the United States, there's a lot of court rules and statutes that actually require certain matters to be brought to mediation, sometimes even before a case is even filed in court. But even if it is filed in court, then before a case can be heard in any way, shape, or form by a judge. And for what it's worth, I'll tell you that if the mediation process is done correctly, it by and large is often much better than going to court. I say that as someone who's been a mediator much longer than I've been an attorney. And I've mediated all different kinds of cases, from no-fault cases to divorce cases and child protection cases, guardianship cases, whatever, you name it, contract cases, farming, agriculture, rural development, all kinds of things. And so from that perspective, I could say that when it's done correctly, it can be a better way to handle things. And it is often much quicker and much less expensive for all involved. So just the act of trying to push for mediation itself isn't necessarily bad. But again, I don't know all the circumstances, but it depends on what exactly you're looking for. But if you really think that there's a violation there, I would start in Michigan. I would start with the attorney grievance procedure through the Attorney Grievance Commission in Michigan. I'd start. It
was a breach of contract claim, and the contract didn't even contain items that are required within the statute for that trade. And then the contractor ended up, doing part of the work, abandoned the work, and it was an insurance claim that was falsely induced to begin with. But then they abandoned the work, then they demanded payment, and the client, asked their insurance company, they want their money now and the work isn't done. What do we do? And so the insurance company advises them, don't pay. And because they didn't pay, the contractor brought the breach of contract claim against them. And really, the contractor created agency with the insurance company, and they should have been part of the claim, but they weren't. So there should have never been a claim. It should have been, if they had an attorney and they reviewed the facts and law, they would have recognized the, motion to dismiss. We don't have anything here. The contract's void on its face. But instead of doing that, they went ahead and milked it along, so to say, for fees.
Right. And so, it just depends on, I realize those are the facts that you're saying, but there's some specifics that would have to be fleshed out as well. But, at the very least, you could start with the Attorney Grievance Commission and go from there. It's been a while, but I want to say the last time I looked at what the attorney malpractice statute of limitations in Michigan was, it was 2 years. So, you could always start with the Attorney Grievance Commission first and let it run its course there. And, depending on when things were, you might be then within the 2 years to file a claim against an attorney for attorney malpractice. So, I'd still start with the Attorney Grievance Commission and go from there.
Okay, super. Thank you so much. I appreciate your help and all your work you do.
Yes. Okay. Awesome. Well, thank you for calling in, and I hope you have a wonderful evening.
Thanks, you too. Bye.
All right, guys. So I'm going to go ahead and throw the website for resources up there. RestoreFreedomKH.com/resources. That's where you'll find all kinds of different things. Oh, we have a caller coming in. I was going to get off the phone now, but I'll take this one quick. Hello, caller. Where are you calling from? Can you hear me?
Yeah, now I can. How are you doing?
I'm doing fine. Where are you calling from?
I am calling from Texas.
Oh, Texas. And what is your name?
They call me Diesel, like a diesel truck.
Okay.
Truck driver.
I was just about to end for the evening because we have to run my daughter somewhere, but is there a particular question or comment that I might be able to handle remotely quickly for you?
So real quick, I'm a little late to do a Valdir, or not a Valdir, but a de novo. And because a bunch of things during Christmas time, and wife got in some medical issues and all that. So I was thinking, since I'm a little late on the de novo, I was thinking about using Valdir and challenging the jurisdiction because it was never been answered. And it's property tax, by the way.
So, okay, when you say a de novo, I'm assuming you mean for filing an appeal?
Yes.
Okay, so generally speaking...
Well, in short, calling out the judge, really, more than anything else, but to try to get a replacement on a judge in that case.
Okay, because what novo means is a brand new review of legal matters.
Yeah.
So when your case is done at the trial level, if you want to appeal it, you might have a right to appeal, or you might have to ask for permission or for leave to appeal, or a writ for a petition for a writ of certiorari. But in any case, if the issues that you want reviewed are factual in nature, there's a different standard of review where they'll look for an abuse of discretion or something like that. But if it's just purely legal issues, the appellate court is supposed to look at it de novo, meaning brand new, and not really worry too much about giving deference to a trial court. But you're talking about wanting to get a judge removed from a case?
Well, not really try to get him removed, but to really either this one particular judge or another judge kind of step in, one or the other. But because the subject matter jurisdiction and in-realm jurisdiction was never clearly established through the whole process. And on my documents, I used one of the people, which puts me in a different venue as a legal person, which is what they're trying to put me under. due to private property issues at hand.
Okay, and venue specifically
But-
talks about where. It's not a jurisdiction thing, it's more about where. So venue would mean just in terms of, is it correct to do it in Orange County versus Volusia County? That's a venue thing. It's not jurisdiction. It's basically saying nothing about whether the court has the right to hear the case, but just which court is supposed to have it. Jurisdiction, though, if you want to challenge subject matter jurisdiction, the general rule of thumb is you can challenge that at any time. In fact, you can even wait till the case is totally over and raise it for the first time on appeal. But it's obviously much better to have subject matter jurisdiction challenged at the beginning. Now, generally speaking, oh gosh, and I don't know anything about the Texas rules of court or anything like that, but in Michigan, it'd be, I think it's a C4 motion, 2.116C4 in the Michigan court rules anyway. But you'd want to challenge, to be able to challenge based on the lack of subject matter jurisdiction, it'd be a motion to dismiss. So if whether it's a civil case or a criminal case, there's some sort of procedure on your court rules to be able to look at how to file a motion to dismiss based on lack of subject matter jurisdiction. So I would go ahead and look at your court rules right away to figure out what the procedures are and what are, how do you have to do that? But that's what you'd be looking for.
Yeah, because at the present time, I'm led to believe and do believe that the judge is a creature of habit ruling on the other side. And when I bring up my document, he didn't even know what I was talking about. So he started asking the other judge, what's he talking about? And all this kind of stuff and all that, which makes me led to believe that, he didn't even read any of my documents. And he just ruled on county's behalf by being a creature of habit.
Yeah, it's kind of interesting. Judges that don't read the pleadings of the citizens involved in a case. Gee, that never happens.
Every time.
My husband was just talking about that today when he's noticed every time that seems to be an issue when, anyway. So yeah, that's the best you can do is you just keep laying the foundation. If you're, at the trial court level, if you know you're stuck with a judge that is not following the proper procedures, not following the statutes, whatever the case may be, and you feel like, gosh, I'm just going to lose at every motion, file every motion that you need to lay that foundation. When you're in hearings or in a trial, clearly lay out all of your objections and state the basis for the record. Do whatever you need to do so that your rights and the issues related to those rights are preserved for purposes of appeal, because that's one of the major things. If you don't raise most issues, if you don't raise it at the trial court level, you can't bring it up on appeal for the first time. So that would be the best thing I would say to do. But
and that was my other downfall, and that's the reason why I was thinking of Valdir. I know most of it's used for attorneys and the juries, but it doesn't have to only be by that way. And at the same time, when I object, I didn't get it fully out. He already declined it right then and there, just snap. He knew what I was going to say, and he already said it before I was halfway through. When I got the court reporter recorder, by the way, people, get a copy of that so you can read through there and see what's been missing, because a lot of stuff in my court reporter was missing. So always get that to, just to get verifiable proof that something is going on in this realm.
yeah.
And, but that being said, that wasn't even on my court reporter. The court reporter completely ignored it.
Yeah. Well,
So yeah, it's an issue.
yeah, it sounds like there's a lot going on there. Well, make sure to look up what your state's court rules are on something that remotely sounds like a motion to dismiss based on a lack of subject matter jurisdiction. And I wish you the best of luck in that situation. I appreciate you calling in. And
Well, and
what's that?
I appreciate you actually promoting this and talking and kind of giving some people ideas, because it's been a long time coming for attorneys to actually do this. And I am led to believe and do believe some of these attorneys now are popping out and saying this is getting out of control.
Yeah. Yeah.
But all righty, I certainly thank you, and you have yourself a fine evening.
Thank you. You too. Bye.
Bye-bye.
All right, guys. So I had up there the resources link earlier. I'm going to also show you, no longer showing. Can you see? Does it show the link at the top of the screen? Because it says it's being shown, but I'm not seeing it myself anymore. Stuff's starting to malfunction. I don't know why, but does it show? Oh, okay. So it says, wait, it says caller on live.
Wait, there it is. This isn't live. Hold on. No.
Oh, so it doesn't
Same
show
thing.
anything at the top. Dang it. Fantastic. Well, anyway, it's not working, so I apologize for that. I was trying to throw some website stuff up on the top for you, but the buttons are not working. Lovely technology. Anyway, restorefreedomkh.com/donate if you're willing at all to help in any way, shape, or form. $5, $10, $20, $50, $100, anything will help. We have domain renewals and things that we're doing this evening. My dad is my web hosting provider, whatever you call him. He's my computer guy. And he said that those are up for renewal. And so we're getting ready to spend a few $100s to get that all going and stuff again. So anything at all that you guys can do to help so we can continue doing things like this and continue providing that website with resources would be greatly appreciated. You can go to restorefreedomkh.com/donate. Square stopped working, but we use PayPal and Venmo, Cash App. Of course, if you're wanting to help specifically for the issue with our fighting against the city of Ormond Beach and the unconstitutional and illegal code enforcement that's happening, that would be the GiveSendGo account, which is givesendgo.com/SaveHenryHome. Anyway, it's been a pleasure to have all of you with us this evening. I noticed Flying Auditor had asked during that last call, how did your case go against the city for trespassing? And the judge punted on that one, quite frankly, as far as having the city's illegally obtained evidence introduced at the special magistrate hearing when they trespassed on our property. Didn't really find merit in the fact that they trespassed on our property. And when I filed the criminal complaints against them almost a year ago, I got not one response. So that was really fabulous as well. If anybody has any interest, if you guys want to check out and you just want to call the city of Ormond Beach and find out, follow up on whatever happened, if they did any investigation, if they opened a case, if they assigned it to anybody, if anybody even read the complaints that I filed, those complaints are actually available right on the website, restorefreedomkh.com/OB-case. I think it's towards the bottom, but you could scroll there and read the actual copies of the complaints that I filed with the city of Ormond Beach. You could ask them for an update on any of that, because I literally have gotten zero response in the last 11 months on those complaints being filed. So anyway, that is that. And all of this stuff is all messed up now. Good gravy. I don't know what this is doing. Now it shows the donate. Oh my gosh. Anyway, I can't get anything to work right here. Anyway, thank you for everyone joining our conversation tonight. I look forward to having you guys join us again soon. At some point, somewhat soon, I will go back on Direct D's channel to talk more about some cases. And I think someone tonight, and I believe it was a separate person that was texting me also about having me on their own YouTube channel to talk about cases and explore things further. We're going to be doing that as well, and then we'll just throw those up on our YouTube channel afterwards. But if you're looking to participate in the next live call-in show, it will be the second Tuesday at noon. So we do the fourth Tuesday at 7 p.m. and the second Tuesday of the month at noon Eastern Standard Time. And by then, I will have my appeal filed. So hopefully I'll have all the documents on the website. You'll be able to check those out and see what it takes to go from one stage to the next. But hopefully Direct D sent you the letter. Oh, I did not get a letter if that was to me. But anyway, it was great having you all in the chat tonight, as well as the calls that we received. And hopefully, if nothing else, I can at least be of an encouragement to you in your own fight for freedom every single day, that you don't sit down and let the government walk all over you, that you can be empowered to utilize the tools, stand up and fight for your own freedom, and don't depend on the politicians, the attorneys, the judges, or anyone else in government to do their jobs, but instead that you can feel empowered and inspired to fight for freedom yourself. And hopefully all together, we will be able to succeed in that endeavor. So with that, I'm going to bid you adieu and run my daughter off to her next thing, and we'll take it from there. Thanks, guys. Have a great night.
Our work to restore freedom would not be possible without support from people just like you. From the various software and hardware needed to the legal research materials, every dollar you can donate helps. Make sure to like and share this video too. And remember to follow and subscribe and click that notification button. Together, we can restore freedom.